Fishbowl, Mahiwagang Fishbowl. Ano ang lalabas sa civil law bar exam? Mahiwagang Fishbowl, Mahiwagang Fishbowl. Doktrina, sitwasyon o probisyon. Mahiwagang Fishbowl, Mahiwagang Fishbowl. Abracadabra, sisbuba, isikriyang forsale!
Isang mahiwagang gabi, mga ka-House of Law, lalo na sa mga kumukuha ng 2024 bar exam. Panahon na naman para basahin ang mga bituin, pakiramdaman ang mga elemento at tuklasin ang mga hula ng Mahiwagang Fishbowl. Pero bago ang lahat, ipapakilala ko muna sa inyo ang aking apprentice na si Princess. Princess?
Hello sa iyo, madam! At hello rin sa inyong lahat! Ako ay nasasabik sa gagawin natin ngayong gabi, madam. Sana ay makatulong tayo sa libo-libong mga examinee ng 2024 bar exam, lalo na sa subject na civil law.
Tama ka dyan, Princess. Aalamin natin kung ano ang posibleng itanong sa civil law bar exam ayon sa ating Mahiwagang Fishbowl. Pero paano kaya hinulaan ng Mahiwagang Fishbowl kung ano ang itatanong sa exam? Examiner ba siya?
Ano ba yan, madam? Hindi siya examiner, no? Ang mga hula niya ay base sa 2024 bar exam syllabus sa civil law, mga Supreme Court decisions na sinulat ni Justice Mario Lopez at mga madalas na itanong ng mga profesor sa law school katulad mo, madam.
Maraming salamat, Princess, sa iyong paliwanag. Kaya wag na nating patagalin pa, hulaan na natin kung ano ang lalabas sa 2024 Civil Law Bar Exam. Question number 1. Lex loci celebrationis, extrinsic validity of wills executed by an alien abroad. Article 17, 816 Civil Code, Cucsar versus Siquito. The situation: a citizen of the state of California, USA, died in the Philippines. Before he died, he executed a will back in California. He had cash and personal properties in the Philippines. The will was presented for probate. What formalities of the will shall be observed? Formalities under Philippine law or California law? If it is the latter, what if the California law is not proved? Question number 2. Unjust enrichment, solutio indebiti, Article 22, 2154 Civil Code, Abelia versus COA, Ngalog versus COA, and Napocor versus Benguet Electric. The situation: through a local ordinance, the city government paid extraordinary and miscellaneous expenses allowance or EME to its officials, which were later disallowed by the Commission on Audit for lack of legal basis. The officials who received the benefits were ordered to refund the amounts. They, however, claim good faith. Can good faith exonerate them from liability to settle the disallowances? What are allowed excuses for not returning the disallowed benefits?
Madam, may isa pang possible situation, sabi ng Mahiwagang Fishbowl.
Ay, oo nga, Princess. Tama ka dyan. Meron pa nga. Thank you, Princess. The other situation: the National Power Corporation sold electricity to Benguet Electric Cooperative, but due to an incorrect multiplier, Benguet Electric was underbilled. Napocor demanded payment of the deficiency, claiming that Benguet Electric was unjustly enriched. However, Benguet Electric asserts that Napocor only had 90 days to correct erroneous billings. Some of the billing statements were more than a year old. Is Benguet Electric liable to pay the underbilled amounts? Question number 3. Tortious interference, Article 1314 Civil Code. The situation: Joe Malone entered into a distributorship agreement with SSI for the sale and marketing of Joe Malone products in the Philippines. A local retailer named Nana Beauty contacted Joe Malone's owners in New York and induced Joe Malone to terminate its contract with SSI, making false claims against SSI. Upon learning about the termination of the distributorship agreement, SSI filed an action for damages against Nana Beauty. Will the action prosper? Question number 4. Change of name, Article 376 Civil Code, Rule 108 Rules of Court, Republic Act 9048, Republic Act 10172, Republic versus Ontuka. The situation: Annabelle gave birth to a baby girl. The child's birth certificate, however, had erroneous entries in the first name and middle name of Annabelle, and in the relationship of the child's parents, it was stated that Annabelle was married to the child's father. Annabelle filed a petition under Rule 108 of the Rules of Court. The Republic moved to dismiss on the ground that the procedure for change or correction of typographical errors is now administrative, pursuant to Republic Act 9048 as amended by Republic Act 10172. Are the courts without power and authority to hear petitions for change or correction of typographical errors in the birth certificate? Question number 5. Effects of absence, defect, or irregularity in the essential and formal requisites of marriage, Article 4 Family Code. The situation: Carlos and Chloe were sweethearts for over a year. They were madly in love, so they got married through a fixer. The fixer made them sign an affidavit stating that they had been cohabiting for more than 5 years as husband and wife. Then they went to a pastor who solemnized their marriage after being shown the affidavit. Neither of them was a member of the pastor's church. A year later, Chloe left Carlos and filed an action to nullify their marriage on the grounds of lack of a marriage license and lack of authority of the solemnizing officer. Will Chloe's petition prosper? Question number 6. Imprescriptibility of actions for nullity of marriage, and that void marriages can be questioned even after the death of either party, as the deceased may have heirs with legal standing to assail the void marriage. Thomas versus Trono. The situation: Thomas was first married to Jane. After 2 years of marriage, Thomas filed an action to declare the marriage void. The court granted the petition. Thomas married again, this time to Tess. They had a daughter, Elvira. Thomas later died. When Elvira went to the court to get papers connected to the case for the nullity of the marriage between Thomas and Jane, it was discovered that the decision was not yet final because the Republic was not served a copy of the decision. The Republic moved for reconsideration and prevailed. Elvira filed an appeal. The Republic opposed the appeal, claiming that she had no legal standing, that only the parties to the marriage can question its validity. Is the Republic correct? Question number 7. Disposition, alienation, or encumbrance of conjugal or community property without authority of the court or the written consent of the other spouse is void. Article 96, 124 Civil Code. Alexander versus Escalona, Strongfort Warehousing versus Banta. The situation: George and Hillary were married in 1966. Through the years, they acquired real and personal properties. In 1998, George waived in favor of his illegitimate son Ray one of the real properties without Hillary's consent. Ray later sold the property to Beatrice. 5 years later, Hillary sought to recover the property because she did not give her consent to its alienation. Both Ray and Beatrice claimed that the action is time-barred. What is the status of the waiver and sale of the property? Can it still be recovered? Question number 8. Substitute parental authority in case of illegitimate children and adopted children. Article 216 Family Code, Section 24K, Republic Act 11642. The situation: Maria and Peter cohabited without the benefit of marriage. They have a love child, Charles. When Charles was 3, Maria and Peter separated due to Maria's drug addiction. A year later, Maria was arrested and convicted of selling illegal drugs. Peter sought exclusive custody of Charles, but Maria's parents, Charles' maternal grandparents, insisted that they should take custody and exercise parental authority over Charles, who between Peter and Charles' maternal grandparents should be granted substitute parental authority. Question number 9. Presumption of legitimacy, Article 164, 167 Civil Code. The situation: Luisa and Noel were married for 7 years, but have been separated in fact for over a year due to irreconcilable differences. Luisa now has a boyfriend, Victor. They have a child, Gabriel. In Gabriel's birth certificate, his father is stated as Victor. Moreover, it is stated that Luisa and Victor are married. To avoid embarrassment from having a child with a man not her husband, Luisa filed a petition to correct the birth certificate to delete the details about Gabriel's father. However, the court denied Luisa's petition and ordered instead that the birth certificate should reflect that Gabriel's father is Noel because Gabriel is presumed legitimate. Is the court correct? Question number 10. Easement of right-of-way, Article 650 Civil Code. The situation: Marisa purchased a triangular-shaped land in Panay, Rizal, which was surrounded on one side by a river and on two sides by the property of Bernard. Marisa's only possible access to the public road is through Bernard's property. Marisa demanded an easement of right-of-way through a 20-meter path which would cut through Bernard's garage. Bernard rejected the request and offered another path which was 3 times the length of the original requested pathway. If this case goes to court, who should the court side with?
Madam, may tanong ako sa'yo. So far, anong masasabi mo sa mga hula ng Mahiwagang Fishbowl? Eksakto lang ba? Tulad ng sinabi ni Justice Mario Lopez sa kanyang message para sa mga bar examinees?
Well, yes. Kasi basic or stock knowledge naman ang mga tanong. Kaya kapag nag-aral, masasagot ang mga tanong. Now to continue. Question number 11. Land registration and judicial confirmation of imperfect title, PD 1529 as amended by RA 11573, Republic versus Pasig Rizal Company. The situation: Junicio inherited a piece of land from his father, who for over 20 years was in open, continuous, exclusive, and notorious possession of said land. To protect his rights to the land, Junicio filed an application for original registration. He submitted proof that the land is alienable and disposable agricultural land. The Republic opposed the application, claiming that the length of possession is insufficient for registration of lands and that Junicio failed to present proof that the land is not reserved by the state for public use, public service, and the development of national wealth. Is the Republic's opposition meritorious? Question number 12. Successional rights of illegitimate or non-marital children, Article 982 and 992 Civil Code, Aquino versus Aquino. The situation: Angela was the illegitimate child of Arturo, who died before Angela was born and before Arturo and Angela's mother could marry. Arturo's family embraced and took care of Angela, and she was treated like family. When her grandfather, Arturo's father, died, Angela asked about her share in the inheritance, but her uncle Rodrigo told her that she was not entitled to a share because she was Arturo's illegitimate child, who is barred under the law to inherit from the legitimate relatives of her father. Is Rodrigo correct that Angela cannot inherit from her grandfather? Now what if it was Rodrigo who died without issue? Will your answer be the same? Question number 13. Forms of contracts, validity, enforceability, and requirement of public instrument, Article 1356, 1358, and 14032 Civil Code, Patenya Kinatakan versus Patenya Decena. The situation: Peter and Paul were the children of Ricky and Amalia. When their parents died, Peter and Paul asserted control over the former's farm in Tagum City. However, they discovered that their parents allegedly donated the property to their aunt Divina. When they investigated, they found that the deed of donation was not notarized and it does not bear the acceptance of their aunt, the supposed donee. They now claim that the donation is void. Are they correct? Question number 14. Oral contract versus written contract, prescription of actions, Article 1144, 1145 of the Civil Code, Alba versus Arrollado. The situation: Rodora sold on credit crude oil and petroleum products to Ninita. Their contract was merely verbal because they were friends. Ninita paid her first check in March 2018. However, it was dishonored by the bank due to insufficient funds. Rodora was not able to collect due to her busy schedule, and then the pandemic happened. On August 5, 2024, Rodora filed a collection suit. Ninita moved to dismiss the complaint on the ground of prescription. According to Ninita, an action based on an oral contract prescribes in 6 years. Rodora counter-argued that the issuance of the check converted their agreement into a written contract. Thus, the applicable prescriptive period should be 10 years. Who is correct between Rodora and Ninita? Question number 15. Continuing guarantee, blanket mortgage clause, dragnet clause, Kiambao versus China Bank. The situation: Elenita borrowed 1 million pesos from XYZ Bank secured by a real estate mortgage, which included a blanket mortgage clause or dragnet clause, a stipulation that the collateral shall remain in effect for loans obtained in the future. A year later, Elenita borrowed 2 million pesos. While the first loan was paid, the second loan was not. XYZ Bank then foreclosed the mortgaged property. Elenita protested, claiming that the second loan agreement did not make reference to the real estate mortgage. Hence, the second loan is an unsecured loan obligation. Did the real estate mortgage also secure Elenita's second loan? Question number 16. Buyer in good faith, mortgagee in good faith. Section 32, PD 1529, Jimenez versus Jimenez. The situation: Caridad owned a parcel of land which she donated to Dennis. After getting a torrents title, Dennis mortgaged the property to ABC Bank. Later, due to non-payment, the bank foreclosed the mortgaged property and acquired it during the auction sale. Meanwhile, Caridad's heirs filed an action to annul the deed of donation, the real estate mortgage, and the foreclosure sale, on the ground that Caridad's signature in the deed of donation was forged. ABC Bank opposed the action, asserting that it is a mortgagee in good faith, that it relied on Dennis's torrents title, and upon ocular inspection was convinced that the property was in the possession and control of Dennis. Who between Caridad's heirs and ABC Bank has a better right to the property? Question number 17. Right of legal preemption and redemption to be exercised within 30 days from receipt of written notice of the sale. Article 1623 Civil Code, Rama versus Nogra. The situation: Riza and Rommel were co-owners of a 5-hectare farmland in Amadeo, Cavite. In late January 2023, Riza sold her one-half undivided share to her sister Marimar. The latter visited the farm and started planting their own in October 2023. Rommel then filed a complaint with the barangay to protest Marimar's actions. During the conciliation proceedings held in December 2023, Rommel offered to redeem the property, but Marimar argued that the time to exercise the right of legal redemption had long expired. Since October 2023, Rommel had personally known that Riza had sold her share in the property to Marimar. Rommel should have redeemed Riza's share not later than November 2023. Has Rommel lost the right to redeem Riza's share in the co-owned property? Question number 18. Special power of attorney in real estate mortgage, Article 1878 Civil Code, Section 1, Act 3135, Commoner Lending Corporation versus Villanueva. The situation: Julian borrowed 500,000 from Enrico, evidenced by a loan agreement with real estate mortgage. Due to non-payment, Enrico extrajudicially foreclosed the mortgaged property and acquired it during the auction sale. Julian filed an action to annul the extrajudicial foreclosure sale, claiming that he did not expressly grant Enrico the power to sell the property. According to Julian, Act 3135 requires a special power of attorney attached to the deed of real estate mortgage. Enrico countered that paragraph 3 of their agreement allowed Enrico to take any legal action as may be necessary to satisfy the mortgage debt. Who between Julian and Enrico is correct? Question number 19. Medical negligence and malpractice. The situation: Natividad underwent surgery for a cyst in her lower abdomen. Post-surgery, it was discovered that the two gauzes were left inside her body. These rogue gauzes led to several complications and subsequent surgeries. Natividad consequently died. Her husband filed an action for medical negligence and malpractice against the surgeon who operated on Natividad. The surgeon countered that it was not his responsibility to account for the gauzes, that he simply operated on the patient. Is the surgeon liable for medical negligence? Question number 20. Moral damages, Article 2217 Civil Code, Scanfield Maritime versus Centeno. The situation: Alvin was hired by SKT Agency on behalf of its foreign principal, Crystal Shipping Incorporated, as a mess person on board MV Northern Stars. On Christmas Eve 2020, he fell from the ladder while working, resulting in injuries. The company-designated physician assessed his injuries and issued a certificate of fitness for work. Alvin sought a second opinion from another physician who concluded that he was permanently disabled and unfit for work. He demanded disability compensation plus damages due to the ship management's and agency's refusal to pay his disability benefits. Is the difference of opinion on the medical condition and refusal to pay sufficient ground to claim moral damages?
Teka, madam. Meron din akong ambag. Napanaginipan ko kasi to eh. Ayoko naman sarilihin to. Baka makatulong din sa kanila, di ba?
Talaga? Natutulog pala mga katulad mo? Paano mo pinipikit ang mga mata mo? Sige, Princess. Ano pa ang mga posible pang itanong sa civil law bar exam?
Mga bar examinees, paghandaan at i-review din ang mga sumusunod ha. Article 4.7 Civil Code, Vested Rights Principle. Article 9.10 Civil Code, Courts to rule based on right and justice. Knutson versus Sarmiento Flores. Article 36 Family Code, Void marriages due to psychological incapacity. Tarandal versus Andal, Kyoge versus Kyoge, Sumilhig versus Sumilhig. Actions to recover ownership and possession of real property. Action interdictal, action publicana, action revindicatoria. Yung legal basis, jurisdiction at prescription ha. Article 681 Civil Code, naturally falling fruits. Article 854 Civil Code, preterition and effects. Last, presumption of regularity, authenticity, and due execution of a contract when notarized by a public notary. Chinko versus Chinko. That's all. And thank you.
Thank you, Princess. At maraming salamat din, Mahiwagang Fishbowl, sa iyong mga predictions. Sana magkatotoo. Kung hindi, di na tayo pati, ha? Maghahanap na ako ng ibang manghuhula. That's it, guys. The predictions for the 2024 Civil Law Bar Exam. Syempre, mga hula lang ang mga yan. Tulad ng sinabi ni Zinaida Seva, hindi hawak ng mga bituin ang ating kapalaran. Ang mga bituin ay gabay lamang. May free will tayo, gamitin natin ito. Tandaan, walang itatanong na hindi nyo alam. You know the law better than the rest of us. Mas may alam pa nga kayo kesa sa amin. Your preparation and sacrifices over more than 4 years will carry you to success. Now, regardless of how many predictions come true, I hope you enjoyed this video as much as I did making it. Sana ay naaliw ko kayo para maibsan kahit konti ang inyong kaba. And with that, our session is over.
Goodbye mga ka-House of Law. Good luck. And God bless you all.
Thank you, Princess, and see you again next year, ha? But I'll see you again soon, guys. Laging tatandaan, isip ay buksan, alamin ng batas. This is the House of Law. Bye, guys! Okay na.